as I do. And if you know the charge sheet, that's the charge. The alighting on the stage, the threatening of the president, etc., etc. There's no other charge. Nothing. You can read that as many times as you like, but it's not going to change. So the question I have for you is, it's possible that there could be mitigation, but even then, I'm not sure that can be correct. I'm not entirely sure what the mitigation is. But perhaps we have to consider that. But let me move on, because you were talking about the postponement, and I wanted to ask you something about that, because otherwise we're going to forget it. Could I ask you whether you wouldn't mind turning to page 401 of the answering affidavit?
Is that volume 2?
I believe so.
Thank you. I'm indebted.
No, volume 1. I'm awfully sorry.
401. Yes, I'm there.
So towards paragraph 192, this is your opponents addressing the question of postponement. And we can move on, because I just wanted to give you an opportunity so I know what your argument is in this one.
Yes, please.
The last 3 lines. The issue, therefore, is not whether this court would have granted the postponement if it had been in the committee's position. The only issue for this court is whether the refusal rendered the proceedings unreasonable and procedurally unfair.
What paragraph, my lord?
I'm sorry, page 401, paragraph 192.
Yes, I'm with you.
Right now, 193. The applicants never made that allegation. They alleged that the request was reasonable and fair. They claim there was no basis at all to refuse it, and they claim that refusal on its own is reviewable and is a standalone basis to set aside the process. But they do not allege that without the postponement, the proceedings were not reasonable and procedurally fair. Even if all the applicants' allegations are true, and they're not, it would not be a basis to set aside the decision. That should be the end of this review ground. Even if this court is willing to read in that allegation, it was not unfair to require them to proceed with the hearing. And then they say, the applicant has not explained why it should have been granted. It's impossible to know which of the reasons they initially advanced they believe compelled the committee to grant postponement, duty on them to explain to the court, etc., etc. Can I just get your response to that?
What is the question?
Well, the question is, this is a justification that they put up for why a postponement wasn't to be granted.
Yes, and I think that my answer is self-evident. My answer is self-evident because of all the breaches in terms of the proceedings as they continue to unfold in respect of my client's ability to have a fair trial in front of the committee.
Sorry, when they asked for postponement, they're asking, what did you put before the committee? For the
page 168, FA 14.
168.
FA 14.
Let me just have a look. No, that's what I want your response on, just that. That's the argument.
Okay, well then look at the contents page. There are the grounds.
Yeah. Is this Mr. Capido here? So he's affidavit. That's right. Mr. Capido, I believe his name.
Miss Cupido.
Oh, Miss Capido. That's so.
168. FA 14.
168 FA 14.
Yes, thank you, my lady.
Yeah. So
you're saying this is, I need to read this to get as the basically this is your case. This was the case.
This was in front of the committee, yes.
yeah.
Okay.
The basis for the
And you say these are the reasons
Yes.
why a postponement should have been granted. Okay, got you. That's fine.
Okay.
No, I wanted to make sure that when I read the two together, I can understand their
Okay.
argument and yours.
May I just, perhaps it would be helpful to give the court the reference to where the FA 14 is discussed
Yes.
in the main affidavit,
Yes,
because
of
then
course.
that adds then the further contextualization
Yeah.
of the review ground. If I could find it in my own papers, that would be, there we go. It concludes at page 32, paragraph 56.2, but the whole analysis about the postponement starts with page 31,
paragraph
54. I don't think there's, I don't know if there's any need to read it out. I'm just pointing it out to you.
Sorry, my only purpose
Yes.
here was to counterpose the 2 points so that
Yes.
one can read them again.
Yes.
And standard
Yes.
that one of the issues which was clearly unreasonable
Yes.
by any reasonable decision maker was the failure to grant the postponement.
Yes.
Which they seem to have followed upon the advice of Mr. Katz, SC.
Pardon?
They seem to have followed that on the advice of Mr. Katz.
Yes, but Mr. Katz is not here, so I'm not going to talk
Yeah.
about the quality of that advice or otherwise.
You're very welcome to if
No,
you
no,
wish
no.
to.
No, he
No,
has
no, no,
filed an
but
affidavit,
all I'm
doesn't he?
simply saying
Yeah,
is
indeed.
they followed that,
Yes, yes,
and that was it.
yes.
Okay, got you. Got
Yes.
your submission. So let's move on.
Thank you. Could I just point out that FA 14 is spoken of, as I said, on page 32, but the analysis and the consequences which flow from that continues then thereafter from paragraph 57 onwards at that page, and it carries on from there.
Thank you.
Thank you.
So that takes care of the postponement problem.
Yes. And you've got my I know we disagree about this point, but you've got my submissions about the materiality of the speaker. I would say that the arguments about the materiality of the speaker as a witness to come and give evidence was also necessary for the president. Because if we go back to the charge sheet, which I think it's perhaps important to do so, because Justice Davis invited me to reread it as much
Yeah.
as I want to, so let's do it together.
What was he supposed to come and say?
Well, let's look at what the charge is. The charge is this. Without the authority, that's what Justice Davis referenced, to do so and advance towards the President of the Republic and the presiding officer in a threatening manner. So,
He wasn't threatened. He didn't
well, we
threaten.
don't know. I think is it on affidavit that the President laughed or something like that? And I'm not sure if we dealt with it. I'm going to look for that reference and
Yeah,
come
there
Mr.
is.
Paso. Is
There
Mr.
is.
Paso speaking?
No, but this is the point, my lady, is that Mr. Kaso is not the president. Mr. Kaso is not the presiding officer. Mr. Kaso may look at these factual occurrences happening and say, oh, I think it's threatening.
No,
Oh, it was very threatening.
This
but
is a
he's
different.
not
I'm not saying this is an irrelevant point. This is
Yeah.
but a different point. The point you now make, which fair enough, I understand,
Yes,
is that this is not about what the Speaker's rulings are. It's the question of whether the Speaker and or the President felt threatened.
on this leg of it,
Yes,
yes.
well, that's
I was-
exactly
I
what you're
was-
reading.
yes.
No, I'm sticking to that. Can I just say, in relation to whether you and I have a dispute, you've been an advocate for long enough to know Council puts difficulties.
Yes.
That doesn't mean we've made a decision. One has to consider your
No, no.
submissions. I just want to make that absolutely clear.
No.
Since it's being recorded, that the public should know we aren't making a decision.
No, Justice Davis,
We're just having engagement.
No,
However robust that may be.
I appreciate that, and I must say it's enjoyable to have such robust engagement
Well,
in the
that's
High
fine.
Court.
I'm very happy that you are.
Yes.
You can buy me a cup of
Of
tea.
course,
at the
there's a
end of
certain
the-
inequity of arms given where I stand and where you
You're
sit.
doing
But
very-
be that as it may, if
You
you
are
can
doing-
invite
you are
me as a
doing very
guest
well,
on your
don't worry
television
about
show,
that.
we can
Okay,
play
so
on
now
the same
we've
playing
got,
field.
so we've got that.
He's still in charge there.
Yes,
We've got,
yeah.
we've got the postponement. We've
The
got the
BCC
question
might
that
say
your
something.
submission now that they should have called the president and or probably president and the speaker.
Yeah.
Should at least at the very least have been called
Yeah.
to explain why they were threatened,
Yeah.
or whether actually, to be perfectly frank, they thought this was a storm in a teacup.
Yes, exactly.
Okay.
And those are the arguments on the threatening part. You've already got my
Got-
arguments on the
yeah.
first part about
Yeah.
the speaker exercise. So then let's just look at the next one about the committee's file written submissions in respect of the sanction.
Yeah.
Can I ask the court to please go back to that code, not the code, the schedule that we were talking about and debating earlier? I think it's at page 7. The relevant one that I want is the para 9, which is at page 82 again.
Is that the penalty one?
Yes, correct.
We're on 82 again, yes? Carry
82,
on.
page 82, volume 1. The point we make here is this, is that when the committee reaches its conclusion on the conviction, or the but I'm saying it reaches its conclusion on the conviction. Obviously, it's a recommendation of the conviction which has to be endorsed by the House. But I think we're all on the same page, 82. The point is this, is that the penalty portion of that proceeding stands on a separate footing. And that's quite clear from the wording
Yes, because
of it.
must be given an opportunity.
So you know what must means in public law, peremptory, can't deviate, and the attempt by our learned friend's clients to suggest that there was some or other waiver or abandonment of the hearing is contradicted by two references on the facts. The first one is, and I'm looking at my learned attorney because she mentioned it to me this morning, so it's both Ms. Naidu and Ms. Cupido who are coming to my rescue. But on the facts of the case, what we know is that even though they left before after the postponement was refused, my clients, even though they left, they were nonetheless entitled, to make to make submissions on sanctions, and they weren't afforded that opportunity because they were said to have waived their rights. That's really the argument.
Was
by
that at the
absenting
time
themselves.
that one of your clients referred to it as a kangaroo court?
Yes, I think so. Wouldn't be the first time that those clients of
No,
mine
it's
use
after.
colourful language.
Was it not after?
Gosh, I didn't realize that.
That
Okay.
is at the merits, isn't it? When
Pardon?
they- At the merits part of the.
Yes,
of the
exactly.
Yeah, yeah,
And
yeah.
then they reach then they reach their conclusion.
And then
that
you're
they
saying,
reached.
at that point, if I can get your submission, sorry, carry on. No, what you're saying is, at that point, the rules are clear.
Yeah.
You convicted them, you say these people are in contempt.
Yes.
However, having said that, they are now entitled as a separate leg of the inquiry
Correct.
to provide representations insofar as sentence is concerned.
Correct.
And your submission is they weren't given.
They won't, and that's because of this doctrine of waiver that is
And you were going to
applied.
give us a couple of references. I
Yes,
think.
that's right. Can we go to FA? Is it FA 19? Apologies for
No,
that.
that's fine.
I was getting the detailed factual submission. So can we maybe start at FA 19 at 258 to 259 in that same volume that we were in?
258, 259.
Yes, please.
This is a letter from Mr. Levitt.
Well, from Mr. Levitt's firm.
Yes,
and
yes, yes,
Ms.
sorry.
Cupido, yes.
Yes, it's from
Correct.
Miss Cupido.
Yes.
I do
So-
apologise for having called Mr. Cupido.
It's
I do
fine.
apologise.
I'm sure she's been called
Reflects
worse.
a terrible
but,
sexist approach which I'm
that's
very
okay.
embarrassed
Very bad.
since I'm sitting with two
Yeah.
colleagues.
Absolutely.
And in fact, if you are going to, you should call us miladies because there are two of them and one of you.
Yes, yeah.
Justice
Anyway,
Davis,
carry
if
on.
you want me to call you my lady, I'm more than happy
I'm
to
more
do
than
so.
happy
You just
if
have
you're
to
going to call us
direct me and I'll
collectively,
do
it's
what you say.
miladies. Yes. No, seriously, it is.
Okay.
Take us to the letter.
Yes, so this is factually how it happens, right? My clients absent themselves from the hearing, which is, if you look at the letter, the date of the letter is as the hearing is concluding, okay? Paragraph 1 at the bottom of 258 talks about the hearing continuing in the absence of our clients. Now this is where our clients have not yet been convicted, okay? And then our clients say, we have instructions to make submissions on the evidence that was led yesterday, and we ask the committee to consider those submissions prior to making its determination on the merits. So, before I move on, maybe we should go to the founding affidavit and to contextualize properly.
Sorry, just that I got the sequence right.
Yes, yes.
We're back to the merits now,
Yes,
not
yes.
the sentence.
Yes.
Yeah, I'm just demonstrating this. Can we go to page 46?
Must read this at 46.
Yes, please. Page 46.
Mm-hmm.
So you can see, for example, at paragraph 111 of that page, that's the summary of why the conviction shouldn't have happened. But I want you to look at 112 at the bottom of the page, please. Prior to the committee making its decision on the merits, a letter was addressed by our attorney requesting the opportunity to make representations before the committee renders its decision. The decision is the conviction, for lack of a better phrase. Letter was sent. Then look at what it says there about when the hearing commenced on page 47. When the hearing commenced on 21 November, the initiator brought our letter to the attention of the committee. Initiator submitted, this is Mr. Katz's advice, that they were making an indulgence. And then the committee ruled that it would not be entertaining any submissions made by the E.F.F. and that it would effectively to proceed to hear only the version put forth by the initiator. Any submissions to be made by the E.F.F. were to be ignored. Can I pause there? That's the narration of the facts of what happened, where my clients, through Ms. Cupido's letter, says, please may we make the submissions before you convict us. Whether for good reason or bad, or opportunistic reasons or not, at FA 18 in that bundle, at page 243, you will see the submissions, those submissions. So despite the committee saying whatever the committee said, my clients put the submissions in front of the committee ignored them. Okay? But that's a conviction issue. We were talking about sentencing, and I'm coming there.
Yeah, because I did read this, and a lot of that had to do with what we've just canvassed about whether it was threatening or not.
Yes.
Yes.
Okay.
Carry on.
But then, if you go back to page 47, because the narration continues, you see that at 117 it says the committee not only refused to take the E.F.F submissions into account in its deliberations, but also proceeded on 22 November 2023 to decide on a recommended sanction without giving the applicants an opportunity to present mitigating factors before it reported to the NA. And then over the page 48, the E.F.F was always entitled, as of right, to make those submissions in terms of reading section 9. And that is because if you look at page 118, on that same paragraph, the NA rules clearly state the process of determining a recommended penalty is distinct from the merits, meaning the committee was required to give us an opportunity to be heard regardless of whether we participated in the hearing.
And that goes back to 9 in...
Yes,
what
yes,
is that? Yeah.
penalty.
Yeah.
That's
the
right.
Must.
Yes, the must.
Yeah, right.
They say in response, the applicant's contention that they were 421 paragraph.
Thank you, my lord. Is that the answering affidavit?
Yes, 263. The applicant's contention is that they were entitled to straddle two horses at the same time as misplaced. Plainly, applicants had made an election when they labelled the committee a kangaroo court and refused to participate.
That's
they
irrelevant.
cannot therefore then claim to be entitled to participate on some semi-formal basis. This will be addressed fully in legal argument. Well, I wait for that, but I'm just saying that's their response.
That's their response. But can we just go back to the schedule then? Because that's a misreading of the schedule of the greatest of respect. Sure. If we go back to the schedule, let's look at what happens here. So look here. The page back, page 81, under the heading hearing. I'm not going to read clause 7. I want to draw your attention to clause 8. It says, if after receiving the notice is the notice of the charge, which is the merits issue, fails without just cause to attend the hearing, the committee may proceed in the absence of the member. Right? So that's how they reached their conclusion on conviction, because they say you absented yourself. What their argument has to amount to, in terms of this attempt to apply a waiver, kangaroo court, and extricating yourself, is they have to read in words to the must in paragraph 9. In other words, that where you fail to attend, based on what it says in clause 8, that means you lose your right in terms of... Yeah. Well, that's how they have to read it, and we say that's not correct, because why would the word must be there? Because must creates the situation that if you absent yourself from the hearing on the merits, that's the risk you take. The committee may go ahead without you, but then when it comes to the hearing, the sanction, that's it.
And if you refuse?
Which we didn't. But if you refuse, that's the risk you take. That must be the case.
Okay. But you say, we never refused.
We never refused, we never got the opportunity. So it's even worse than that.
So the obligation moves to the committee.
Yes.
In 9.
Yes.
Yeah.
So your submission on this, just to round it up, is that when it comes to sentence,
yes,
there's no we can argue the debate about whether, in fact, the committee was justified in granting a postponement
Yeah.
with regard to conviction.
Yeah, yeah.
But what is absolutely clear is there's a peremptory requirement which would require a clear waiver, as I understand
Yes.
your argument, insofar as sentence, you were never given the opportunity in that
Yes.
regard. Okay, got
And
it.
in the main heads of argument, we take this point. We demonstrate that there's no waiver.
No,
but
I've read the
I
heads.
don't think that...
No,
I'm
that's what-
indebted. I'm not going to go there.
We've got the point.
Thank you.
We can move on.
Okay, I think I've already debated the committee's decision that the applicants are found guilty, and we've debated that already. The related decision, the committee's refusal to consider the applicants' written submissions. Because what we know, and if I can ask the court... go back to the schedule, page 81. I don't know if you've moved beyond the schedule.
No,
Oh,
got
we're
it.
there, we're there.
It's emblazoned in my mind.
Yours and mine both, Justice Davis.
We're there, yeah.
But look at what it says in the tail end of clause 7 under hearing. It says, after all the witnesses have been called, the member or fellow member may sum up the evidence and make a presentation to the committee. So we would say that that's really the function of the merits submissions, which the committee ultimately ignored. And it ignored based on the evidence of Mr. Katsesi, because once you have allegedly absent yourself, then you lose the right to even put that in front of the committee. And we say
That deals with the merits.
yes.
Huh?
There is a difficulty, obviously, one should be careful about this, just in general terms. I mean, people can actually refuse to go.
Yes.
And, I mean, at some point, committee's got to do something.
Yes. No, that's correct. But I mean, and these internal contradictions are based on the wording of the schedule. Because if you look at the same page 81, it says, if after receiving the notice the member fails, comma, without just cause, comma. What's just cause? Is just cause only a medical appointment? Or you say that and Justice Davis, I do this, I tread very carefully. Is it because the speaker improperly exercised her powers which gave rise to these hearings and therefore I don't recognize them? Is that just cause? So that's the point we make.
Okay, got you.
Thank you. I see it's almost lunchtime. I've got a few more submissions to make.
No, we're going to carry on for one. We've got another 10 minutes. Carry on.
Oh, is it 10? I've got 5 on my side.
No, we'll give you 10.
Yeah, oh, 5 more minutes. Sorry. Well, why don't we wait? You can use the 5 minutes.
Thank you.
You can wrap up after lunch, but
Thank
take
you.
the 5 minutes.
I'm indebted to the
Yeah,
court
yeah.
and the staff. Okay. Then, related to the first bundle of decisions, this is all in the context of the proceedings and what happened. The two things that we particularly take issue with is we take issue with the sanction that was recommended.
Yeah.
You'll remember that there were two parts to the sanction. One was the apology,
Yes.
and then it was coupled with
The 30 days.
the 30 days.
Yes.
And based on the earlier debate we had about how you read 12.5 and 12.9, what we say is that the evidence coming out in the answering affidavit as to how they reached their determination on that sanction doesn't find expression in the committee's report, in the recommendation, in terms, because remember, that's the obligation created by the Act. The Act says in 12.9, you have to engage with why the other things are inappropriate before you go to 5G. And they didn't do that in the report. And it's not open to them to justify this after the fact in the answering affidavit. So the point is that the sanction falls to be set aside because, to borrow their language, they try to straddle two horses. They make you do the apology, which is one of those things that could be a sufficient remedy under 12.5, coupled with everything else before G, and then they reach for G without telling you why G is applicable in the absence of everything else that they could have sanctioned my clients in terms of. So, insofar as the sanction, never mind the absence of Audi, which is what we were just debating about, must under clause 9 of the schedule, there's also here an internal problem in terms of recommending the sanction that they did because they failed to adequately discharge the onus on them in terms of the Act.
Got you.
I'm indebted.